Supreme Court Justice Roger B. Taney. Taney was born March 17, 1777, in Calvert County. His mother's name was Monica Taney, and his father's name was Michael Taney. They owned a tobacco farm and had 6 children. Taney was the second child, so he knew he would grow up and would not inherit the family business, so he went to school and pursued law. Taney attended Dixon College and graduated from there in 1795. He then studied under Judge Jeremiah Chase of the Maryland General Court, where he then passed the bar in 1799. He soon turned to politics and became a member of the Federalist Party and was elected onto the Maryland House of Delegates. Then, in 1816, he earned a spot on the Maryland Senate as a Democratic Republican, where he served a time of 5 years. In the presidential election of 1828, Taney supported Andrew Jackson, and when he won the election in return, Andrew made Taney Attorney General in 1831. Taney proposed the undoing of the bank to the Senate, and it was denied. But to reward him, Andrew then wanted to appoint him for Supreme Court Justice in 1835. But due to his controversial view on the undoing of the bank, the Senate rejected him for Supreme Court. Later, in 1836, Chief Justice John Marshall died, so Andrew again appointed him, and he was approved by Senate. He became the fifth Supreme Chief Court Justice and the first ever Roman Catholic to lead the United States Supreme Court. Later, he swore in President Lincoln into office and remained on the Supreme Court bench for 28 years. An African American man who was living in the state of Illinois was a free man, but he wanted to move to Missouri and keep his freedom, even though it was a slave state. It came out to a 7-2 decision, and it was not in Scott's favor. Taney went on to say that African Americans were not United States citizens, therefore they had no rights and did not have a say in their freedom in certain states. He also claimed Chief Justices could not forbid slavery in U.S. territories. He received lots of backlash for saying these things, especially for a certain phrase: "Blacks have no rights which the white man was bound to respect." Taney had 5 daughters with his wife Anne Key. His daughter Alice died in 1855 of yellow fever, and his son Augustus died at infancy in 1815. His brother-in-law Francis Scott Key wrote the Star-Spangled Banner. Taney died on October 12, 1864, in Washington, D.C., and was buried in Maryland.
Supreme Court Case Snyder vs. Phelps. The people involved in this case were Marine Lance Corporal Matthew Snyder, father of Matthew Snyder, Albert Snyder, the Westboro Baptist Church, the WBC founder Fred Phelps, the District Court of Maryland Judge Richard Bennett, and Chief Justice John G. Roberts, Jr. The case was granted on March 8, 2010, but it was argued on October 6, 2010, and was decided on March 2, 2011. The case originated in the United States District Court for the District Court of Maryland, the birthplace of Matthew Snyder. The case was also involved in the lower court, United States Court of Appeals for the Fourth Circuit, and the location of the suit took place in Garrison Forest Veterans Cemetery. What happened in the case was that Marine Lance Corporal Matthew Snyder was shot and killed in battle while in Iraq. His father, Albert Snyder, decided to have the funeral take place in Matthew's hometown of Westminster, Maryland. Due to the notable death, news outlets publicized the time and location of the funeral. Fred Phelps, founder of the Westboro Baptist Church, took note of the time and location, gathered 6 other members from the WBC, and decided to travel to Maryland. While in Maryland, the WBC picketed and protested the Marine Lance Corporal's funeral. Albert Snyder filed a lawsuit against Phelps, his daughter, and the WBC in the U.S. District for the District of Maryland under the court's diversity jurisdiction. Snyder alleged Phelps of 5 state tort law claims: defamation, publicity given to private life, intentional infliction of emotional distress, intrusion upon selection, and civil conspiracy. The District Court of Maryland ruled in favor of Phelps and Westboro. Because of this, Snyder took the case to the Court of Appeals. There, he won the ruling and was awarded $10.9 million, $8 million which was in punitive damages, and $2.9 million in compensatory damages. Due to the ruling that was made in the Court of Appeals, Westboro took the case to the Supreme Court because the court ruling was in violation of the First Amendment clause of freedom of speech and freedom of religion. The main argument of this case was whether or not the signs being picketed by the WBC was of private or public concern. It was also whether or not the First Amendment protected the actions and the picket signs of the WBC. The court decision was yes. The First Amendment protected all of their actions and words on the signs. The court decided that the signs being picketed were of public concern and not of private concern. Therefore, everything that was being used by the WBC was valid and did not violate any of the amendments. American society has been both motivated yet cautious. People have been more motivated to make adjustments to the examination of cases that violate the First Amendment. However, they've also been more cautious in terms of what they consider something a violation of. Phelps and the WBC are an example of those who use the technicality of their rights to have leverage over those who are in a vulnerable position, and ultimately, due to the decision by the Supreme Court, can be held non-accountable for their harmful actions.